Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
Not coincidentally, they are deriving that single best meaning from the date of enactment of the Constitution or the statute. So, it just happens to be 225 years ago and there aren't any extant records to prove them wrong. But it's actually worse than that, right? Because if legal principles have a single mathematically correct metaphysical answer, why should the Supreme Court bother to listen to lower courts at all, right? Mm-hmm.
Welcome to Law and Chaos, where today it's all chaos thanks to the Supreme Court. They're blowing up nationwide injunctions, they're cutting the legs out from under lower court judges, and they're pretending children's picture books are porn, which is weird, because they're also taking away your actual porn in Texas. We've got a lot to cover, so let's get after it. Hey guys, I'm LizSky, and with me as always is Andrew Torres. Andrew, how are you?
I'm great, Liz. How are you?
I mean, I'm all right. It's awful hot here, and
Did you have a nice weekend at least?
I did. How about you?
Mine was great. Mine was wonderful.
All right. Well, I guess we should get right into it.
Okay. So, as you said in the intro, the Supreme Court ended its term on Friday, and as we predicted on our last episode, it handed down some truly terrible opinions. We're going to talk about all of them with a particular focus on the two most consequential, that is, Mahmoud v. Taylor, a decision radically reinterpreting the First Amendment's free exercise clause, as well as Trump v. CASA, the birthright citizenship case where the Supreme Court discovered that courts issuing nationwide injunctions, something they have been doing for more than a century, is actually unconstitutional. Who knew?
Yeah.
Yeah, we wrote about that case first at Above the Law on Friday and then at lawandchaospod.com yesterday, and we will link to those stories in the show notes. But essentially, the Supreme Court's howler monkeys know that they have the power, and they will have it unchecked for at least another decade, unless something changes radically. And so they are taking power away from the lower courts, which are very conservative, but might not be 100% on board with the conservative project.
Yeah, I think that's exactly right. This is the Supreme Court saying, we are the only law in the land, and we don't want any uppity trial judges thinking they can say what the law is for America.
All your base belong to us.
Exactly. But first, let's talk about the other four decisions that the Supreme Court handed down before getting out of town to go drink melted glaciers on Harlan Crow's yacht, I assume. Mm-hmm. One of the four was a punt. That's Louisiana v. Calais, which is a challenge to the last remaining vestige of the Voting Rights Act. Specifically, Section 2 says it's illegal to dilute the voting power of black voters when white voters vote as a bloc. A coalition of white voters sued, saying that Louisiana's congressional map containing a second majority black district constitutes an illegal racial gerrymander that violates the Equal Protection Clause. The trial court and even the Fifth Circuit said, no, the VRA is the law. And the Supreme Court heard oral arguments in this case in March, but has now relisted it for the next term with additional briefing.
Which seems ominous, but if you're looking for a silver lining, I would add that the longer you push off redistricting cases, the more likely you are to run into the Purcell principle, right, which says that courts should not change election rules close to an election, although I regret to say that puts me in agreement with Justice Clarence Thomas, who wrote a dissent saying that the court should have decided this one now. So maybe
I read this all as very bad. I suspect that the conservatives are staggering their attacks on civil rights in hopes of preserving the court's legitimacy.
Preserving? Yeah, good luck with that one.
Yeah, I would note this is basically the inverse of the Alabama voting rights case, Allen v. Milligan, where SCOTUS has twice told the state that they really do have to redraw their racist gerrymander of a map, and they keep not doing it. Alabama appealed a third time. But in that case, Justice Kavanaugh wrote a concurrence that said basically, we will have to revisit this Section 2 issue sometime, just not today, Alabama.
Yeah, and I think Kavanaugh's concurrence seems to have emboldened the state of Alabama to continue to defy the Supreme Court, along with these dipshits in Louisiana.
Yeah, okay. In terms of actual decisions, 2 were the Supreme Court reversing the Fifth Circuit, which seems to happen quite a lot, more than
Yes,
any
does.
other circuit. Each decision was 6-3 with Thomas Alito and Gorsuch in dissent. The first is Kennedy v. Braidwood Management. It was authored by Justice Kavanaugh. It concerns the U.S. Preventive Services Task Force, which is a government body under Health and Human Services that formulates evidence-based recommendations regarding preventive healthcare treatments. It was created in 1984 by Ronald Reagan's HHS, and it has 16 volunteer members appointed by the Secretary of HHS to staggered 4-year terms. Before 2010, the task force's recommendations were purely advisory. That was indirectly changed by the Affordable Care Act, which required most insurers to cover preventative services without cost, as long as those services receive an A or B rating from the task force.
Right, and that is really sensible, and I might add, economically conservative policy, right? Like spending money in healthcare on prevention early is orders of magnitude more effective than spending money on expensive testing and treatments later in life.
And yet, a bunch of insurers did not want to pay for those preventative services, like the lead plaintiff, Braidwood Management, which runs a health and wellness center offering insurance coverage to its approximately 70 employees through a self-insurance plan. They argued that because the ACA made the task force recommendations legally binding, that means the task force members are now principal officers under the Appointments Clause. So they can't be appointed by the Secretary of HHS. They must be appointed by the President with the advice and consent of the Senate. That would make every recommendation the task force has issued since at least 2010 void ab initio and free up Braidwood from having to pay for pap smears and mammograms and well visits.
Yeah, and the Fifth Circuit, we should say, was all in on that theory, but 6 justices at the Supreme Court were like, yeah, that is crazy. These guys are obviously inferior officers, right? They have no independent authority. They are directed and supervised by the Secretary of Health and Human Services, who can fire them at will and block any of their individual recommendations.
Yeah, I just want to point out that the Appointments Clause, and a quite similar argument to this, was what Trump did under Eileen Cannon to get rid of the stolen documents case by arguing that Special Counsel Jack Smith should have been Senate confirmed because he was a principal officer. This is a kind of a kook argument. But once conservatives have attached themselves to a kook argument, they're kind of stuck with it because otherwise they'd be acknowledging that Donald Trump had put forward a kooky argument.
That is a really, really interesting theory. And look, this is a good result in at least 6 justices on the Supreme Court saying we're not going to embrace that kook theory. But in terms of the implications of this decision, right, like, good that it does not retroactively undo over a decade of, preventative recommendations that are based in evidence. But in terms, if you're thinking about reining in the power of the Trump administration, I don't think this opinion does anything, right? Like, Trump can and will, since the holding is that they are inferior officers, he can just tell RFK Jr., the Secretary of Health and Human Services, to fire the task force members, which I imagine Trump will do any day now, and, then replace them with a bunch of Reiki practitioners who cure allergies with crystals.
Yeah, jade egg. I'm holding out for the jade egg commission.
Center your yoni.
Y'all, I'm not going to explain this one. You can just Google jade egg, Gwyneth Paltrow. That's all that we need to say here.
Maybe not from work, though.
Next up, Federal Communications Commission v. Consumers Research. This is a good result. It's the same 6-3 alignment, this time with an opinion written by Justice Kagan. This was a challenge to the funding mechanism for the Universal Service Fund contained in the Communications Act of 1934. That law created the Federal Communications Commission, or FCC, and required the FCC to make available to all the people of the United States reliable communication services at reasonable charges. Today, that mandate is called universal service, and it's roughly analogous to the Postal Service's last mile principle, right? The idea is that there are very poor and very rural areas where if you just rely on the free market, there will not be broadband internet access. And so we all have to pitch in and fund it because it's a common good.
Yeah. Federal Express will not deliver a package to uncertain Texas, home to 85 people on the Louisiana border, right? Like, no matter how much you offer to pay them. And there are some things that we think you should get, even if you live in uncertain, right? And up into the 1990s, that was mostly telephone service. And what the federal government did was directly subsidize long distance for people who lived in uncertain.
Right. And look, I take your point about for any amount of money, FedEx will not deliver. But that's sort of anti-democratic. The purpose of these last mile things is like, it costs, whatever it is, 38 cents to mail a letter down the street, and it costs 38 cents to mail a letter to remotest Alaska, because we as a nation believe that we should have universal access, that it's part of living in a democratic society, that there aren't going to be people who are basically off the grid, because of cost. So we believe in leveling out the costs, equalizing it.
Yeah. And in 1996, Congress amended the 1934 Communications Act to include internet access as one of those things that if you don't have, you're effectively off the grid. And the way they had to implement that is a little different than the mail and telephone, right? Like, so what they did by statute was require telecommunications carriers to contribute to something called the Universal Service Fund. Those amendments to the statute also provided detailed, explicit guidance as to explicitly how the FCC shall spend that Universal Service Fund to subsidize, and primarily it is rural hospitals, schools, libraries, things that we think, definitely need the internet.
Right. So the statute mandates that the FCC shall consider the extent to which a service is essential to education, public health, or public safety, and has been subscribed to by a substantial majority of residential customers before subsidizing. It also says the FCC must evaluate whether a service can be made available at an affordable rate.
Right. So a bunch of libertarian types sued on behalf of the poor beleaguered telecommunications companies, saying that the fund, violated the non-delegation doctrine. And if you're wondering how we got there, right, like their theory was that Congress can't delegate how to subsidize rural broadband because it's secretly a kind of tax, and taxes can't be the authority to tax can't be delegated to the FCC, although apparently it can be delegated to Donald Trump. But let's not go there. Anyway, the argument was Congress has to do it directly, and that would have the practical consequence of grinding rural subsidies for broadband to a halt because Congress can't do anything.
And it would have the effect of grinding the expansion of access to broadband to a halt in rural areas, because market forces will never bring it there. It will never make sense to bring affordable rural broadband to rural areas.
Right.
So the Supreme Court in this 6-3 decision said, no, this is a regulation. So it only had to pass the Roberts Court's usual test for non-delegation. That's called the intelligible principle standard, which is that Congress has articulated clear directives for the executive branch agency to follow, which it has.
Yeah. And I just can't help but think that this is another item to add to the pile of decisions by this court where, the primary consequence is going to be to benefit the people who have overwhelmingly voted for Trump and to put the people in place on the Supreme Court and in the legislature that want to take this benefit away from them. But,
Okay, it is Tuesday, and that is the day we thank our new subscribers for the week. So, over on patreon.com/lawandchaospod, thank you to Keith Lewis, Carl Pidgeon, Susie Thompson, Villanueva94, Linda McGuire, Shoshana, and Jennifer Harris.
And on Substack, a big thank you to Randy Goldberg, thank you, Doctor, to Louie, Diane Begess, Carl Blaze, I know who you are, and Crazed Desk. And if you'd like to join their ranks, help us keep doing the show. Get the shout out, the extended episodes, the ad-free episodes, all the bonuses. You know how to do that. Just head on over Substack, that's lawandchaospod.com, or to Patreon, which is patreon.com/lawandchaospod. Sign up to give us as little as $1 an episode, and we will shower you with all the goodies, including skipping this ad break that is otherwise going to come right now.
Okay, last up we have Free Speech Coalition v. Ken Paxton, the Texas Attorney General, and perhaps the state's next senator. He is mounting a challenge to Texas Senator John Cornyn.
Let them fight.
Aha. So this is a Clarence Thomas opinion. It is 6-3 with the sensible justices in dissent. And we will probably have an expert back on to break down just how crazy this opinion is. But here is the TLDR. The Supreme Court just upheld a Texas law, HB 1181, which requires users on websites with adult content to submit age verification, even though that flies in the face of prior precedent and the mechanism doesn't work.
Yeah, and from a legal perspective, this opinion is a disaster because it radically diminishes the doctrine of intermediate scrutiny. And remember, scrutiny is basically the standard imposed on the government to prove that it needs to pass a law that would otherwise violate your civil rights. So Equal Protection Clause cases can trigger strict scrutiny, in which the law is almost always struck down, right? If you want to pass a law that says black people can't drive after midnight, but white people can drive whenever, that's going to require strict scrutiny, and it is going to fail. On the other hand, the lowest level is rational basis scrutiny, which the law is almost always upheld. The state only has to prove that there is a rational relationship between a legitimate goal and what the law does. And in the middle is intermediate scrutiny, in which the law is typically struck down. So if a law, as we said, discriminates on the basis of race, it gets strict scrutiny. If it discriminates on the basis of gender, it gets intermediate scrutiny.
And typically, when a law infringes on a constitutional right, that triggers strict scrutiny. Mm-hmm. But the Supreme Court said this one only triggered intermediate scrutiny because it only, quote, incidentally burdened the protected speech of adults.
Really?
Thomas says that no person, adult or child, has a First Amendment right to access pornography without first submitting proof of age, because that's an ordinary and appropriate means. He draws an analogy to other forms of age verification that states use, like buying alcohol, tobacco, and firearms. And since you have to show ID to buy Playboy in a 7-Eleven, you can be forced to do so on the internet. I will say, I have no idea if they still sell Playboy at the... I mean, why would they? Who is buying a skin mag at the 7-Eleven in this day and age? But yeah, I mean, maybe some people are old school. I have no idea.
I will say, the intermediate scrutiny analysis here is bizarre, right? I assume, for the sake of argument, I'm not sure that this is the case, that it is a legitimate state interest to restrict minors from looking at porn. Texas HB 11 requires every single person to submit a government-issued ID to verify your age. And look, like, people are not going to submit their driver's licenses to porn websites. That is just begging for identity theft, right? Here's what they're going to do. Don't take legal advice from a podcast. You're going to get a VPN. They're free VPNs out there.
You ought to have a VPN anyway in this day and age,
yeah,
right?
And just set it, to, oh, hey, I'm accessing this from not Texas, and you're fine, right? And I want to point out, for the websites themselves, the penalties for noncompliance with HB 1181 are beyond severe, right? Companies can be fined $10,000 per day that they're not in compliance with the law, and $250,000 per violation anytime someone under the age of 18 manages to access the site. So, unsurprisingly, the day the decision came out, Pornhub shut down in Texas, which I know because Ken Paxton is bragging about this on his website, which seems like a weird flex.
I mean, he should only run on that as a platform. Like, let him get out of the primary. I don't care. Let him win. Let him win the Republican primary, and then run on a platform of I took away your porn. Like, dude, I dare you. Courage of your convictions.
Let's win that Senate seat in Texas.
Okay.
All right. I want to talk about jurisprudence. Because one of the things that we've said on the show a lot lately is the Supreme Court got it wrong, right? Like the clearest example, the wrongest the Supreme Court has been, although, there are no shortage of choices here, is Trump v. U.S., the presidential criminal immunity decision. But think about what it means to say the Supreme Court got it wrong, right? That implies that there is a way to get legal analysis right. And so the notion that there is a right and a wrong way to interpret the Constitution is called jurisprudence. That's the theory of how the law ought to be interpreted. And whatever your theory of jurisprudence is affects how you perceive judicial opinion. So an extreme example, right? This is now a very fringe position, but it certainly has a long history dating back to 13th century Saxony and before, right? If you say the law is whatever the king says it is, or whatever the Supreme Court says it is, then it makes no sense to say that the Supreme Court got it wrong, right? Like, that's a category error. Definitionally cannot be true. But The American experiment in the 18th century drew inspiration from John Locke and his Second Treatise of Government, right? The idea was that there was a natural law and natural rights. And so if the king transgressed those fundamental principles, the king was wrong. And you could rightfully rebel against him and overthrow him and cite these kind of higher principles as justification for doing so. And some version of that natural law idea really persisted as the dominant strain of legal thought until the late 19th century. I would group them all under the category of legal formalism. And you can also see the influence of the Enlightenment kind of more broadly here. The idea was that the true meaning of the law was this sort of Platonic ideal, but it was out there, right? Kind of floating in the ether. And so what judges were supposed to do was rigorously apply logic and consistently apply the, fixed normal rules to the cases in front of them in order to discover that right answer, right? Like at its most rigid, legal formalists thought law was like, Kepler figuring out the laws of planetary motion, right? Good judges were like scientists. The right answer was out there to be discovered.
Balls and strikes, if you will. Yeah. But then, in the late 19th and early 20th centuries, judges and legal theorists started noticing that this mystical natural law thing sure seemed to coincide with the interests of big business. The Supreme Court was in its Lochner era, and pretty much every effort to aid workers was getting struck down. And in terms of predicting how courts would come out, you would have a much better track record if you just predicted courts are going to side with big business rather than trying to comb through their opinions to find out which legal principles were being applied. And that brings us to the critique called legal realism, which we will talk about after this brief ad break. And we're back. Okay, so we were talking about legal realism, a concept associated with Justice Oliver Wendell Holmes. And one particularly illustrative case was called Southern Pacific Company v. Jensen. In 1917, the Supreme Court held that the family of a railroad worker who was killed while on the job was not covered by workers' comp.
It's a bit surprising. Look, workers' comp law was not great in 1917, but there were both federal and state laws protecting railroad employees because the railroad was pretty important, right? So you'd think at least one of those laws would have applied here, but you are not the Lochner court. So the Supreme Court said, even though Jensen worked for the railroad, and even though he was killed loading stuff onto a train, he was loading stuff off of a boat. And okay, the boat was A, docked, and B, also owned by the railroad, but never mind any of that. Boat equals admiralty law. And because Congress didn't say that federal workers' comp law applied in interstate maritime transportation, that's the language of the opinion, that means it didn't. So, look, ordinarily when Congress is silent, courts will let state law fill in the gap. So, you would think here, New York did in fact have a state workers' comp law. But the Supreme Court said, no, that wasn't any good either because a federal court sitting in admiralty jurisdiction could only apply state law remedies that were available at common law. And since 13th century Saxony didn't have any workers' comp laws, Jensen's family was just out of luck.
Yeah, so Justice Holmes called bullshit. He did not say it was bullshit. He said that the law is not a brooding omnipresence in the sky.
Yeah, that's 1917 for bullshit.
He said that the law is a result of our choices, and we should recognize that the Supreme Court is choosing to side with the railroad. Lots of state Supreme Courts had chosen to side with the workers. And that notion that the law is in some independently existing holy writ out there to be discovered, it's a thing we create as real people. That's legal realism. And judges, particularly Supreme Court justices, should be cognizant, Justice Holmes said, of the real world impacts of their decisions have on the people we're making them about.
Yeah, and that was a bombshell in terms of legal thought. I mean, it seems pretty standard today, but I guess I should say a couple of things here, right? First, legal realism also has its flaws, right? Like if the law is only what judges say it is, that also seems kind of unsatisfying, right? Like are there no fixed principles? Like why should you follow the law at all? Why would you have an independent duty to do so, particularly if you disagree with it? So, okay, this is way oversimplifying. I could spend hours in the weeds here. I love this kind of stuff, but it is out of that clash between legal formalism and legal realism that developed what I call the ordinary model of jurisprudence that operated from about 1940 until about the Roberts Court, right? And it goes like this. It says, okay, easy cases are formalistic rules. If the law says speed limit 55 and you're going 80, you're guilty, right? Even if you're a way better driver doing 80 than someone else doing 55, you don't look to the principles, you just follow the rule. But we recognize that there are hard cases, right? Like you're driving a pregnant woman to the hospital, or you're clocked at 57, but the radar has a margin of error. And in those hard cases, you do look to the underlying principle, right? Courts should try and apply that to the facts as those facts have been explicated over time.
And that's true for the Constitution as well. It does have some formalistic rules. The Third Amendment says the government cannot quarter soldiers in your home. We know exactly what that means and why it's in the Constitution. It doesn't have a larger animating principle. But most of the Bill of Rights articulates principles, right? What is freedom of speech or the free exercise of religion? What's process and how much of it are you due? What does it mean to have equal protection of the laws?
Yeah, and the answers to those questions are not easy. They were not intended to be. And this is where stare decisis comes in, right? If a prior Supreme Court says that due process means that you get to have a hearing with your lawyer present before the government can take away your rights, then we're starting to define what due process is, right? And how it gets applied in certain situations. And that's why the Supreme Court should ordinarily be bound by prior precedents unless something has gone utterly and disastrously wrong, right? It's not because the prior decisions were correct in a metaphysical sense, right? It's because this is what the rule of law means. It means that people for decades or longer have been relying on the prior court's decision and trying to conform their conduct to it. And so the Supreme Court today shouldn't jerk that reliance out from under the public, even if it thinks that the old court got it wrong. And, even if this court might have come out a little differently if it were being decided in the present. That instinct, the idea that the rule of law means you can conform your conduct to what the law is the influence of legal realism, right? Like we just understand that there isn't one right answer to the law. And the strongest articulation of this principle in modern times, I think, is the Supreme Court's 1992 decision in Planned Parenthood versus Casey. That was a case in which a very conservative Supreme Court, staffed with a supermajority of Republican appointees, right, from Nixon to George H.W. Bush, nevertheless refused to overturn Roe versus Wade. Justice Sandra Day O'Connor wrote, "Liberty finds no refuge in a jurisprudence of doubt." And so even though she says she would have gone the other way had she been on the Supreme Court in 1973 when it decided Roe the first time around, she says, look, it's a disaster if the Supreme Court just reverses cases every time we disagree with what went on in the past. Instead, what she said is that the Supreme Court should honor stare decisis, deviate from prior precedent only if the central rule of the prior case has been found unworkable, or a doctrinal anachronism, or that its foundational premises have so far changed as to render its central holding irrelevant or unjustifiable. And that's a huge bar.
Right. And we have now witnessed several years of the Supreme Court blowing up all precedent, ignoring stare decisis, right? The Roberts Court has jettisoned precedent. We've talked about originalism, which is how the court's conservative justices describe their own jurisprudence. And that's basically a fig leaf that says, okay, all the stuff that happened in the past 100 years, screw all that. We would like to reach a different result. And so we're going to go all the way back. We're going to say that we are adhering to the real precedent, which just so happens to be several hundred years ago, before all of this modern era took place. And in a lot of ways, that's a sort of a formalistic fig leaf. And the clearest expression of that is in the last term, when the court overturned Chevron deference, in that case, Loper, Bright, Enterprises v. Raimondo. In that case, Chief Justice Roberts' reasoning was legal formalism, but it was a really radical invocation of that. He said, courts understand that statutes, no matter how impenetrable, do, in fact, must have a single best meaning. That is the whole point of having written statutes. Every statute's meaning is fixed at the time of enactment. So in this incantation, every legal principle has a single right answer, as if each case were a math problem, right? 2 + 2 = 4, and only 4. And one consequence of this view of law is that stare decisis is like irrelevant, right? If you're reevaluating it to find the one true answer, what does it matter what American courts have said for the past 200 years if they got the answer wrong? And what does it matter if they got it right? The only thing that matters is that the single best meaning gets applied. And by the way, spoiler alert, guess who gets to determine the single best meaning?
Yeah, that's right. And not coincidentally, they are deriving that single best meaning from the date of enactment of the Constitution or the statute. So, it just happens to be 225 years ago and there aren't any extant records to prove them wrong. But it's actually worse than that, right? Because if legal principles have a single mathematically correct metaphysical answer, why should the Supreme Court bother to listen to lower courts at all? Right? And under the ordinary model of jurisprudence, the one that you and I grew up with in law school and defend, that question, why should the Supreme Court care about what lower courts have to say, has straightforward answers to it, right? Like you want to listen to the trial court because that's the court that's made the factual findings. They've held evidentiary hearings. They've developed the record of what actually happened. The best way to know how to apply general principles of law to novel factual situations is to defer to how the trial court articulates that factual situation. And you also want to listen to what appellate courts have said about the law, because appellate courts are supposed to, anyway, scrupulously apply prior Supreme Court precedent, right? The Supreme Court can say, oh, we got it wrong. But the Fourth Circuit can't just say something like, oh, yeah, we think the Supreme Court was out to lunch when it decided DC v. Heller, right? So we're just going to ignore it and uphold Maryland's assault ban anyway. Instead, they have to say, look, we're bound by DC v. Heller. We might not like it, but even under DC v. Heller, here's why this law is constitutional. But if precedent is only meaningful if you get to the single right answer, why should the Supreme Court care what some dumb lower court has to say?
Which is pretty much exactly what Justice Brett Kavanaugh said in a concurrence in the Alien Enemies Act case. Remember, that's the only time the Supreme Court has ruled against Trump. That was the 1 a.m. stay that prevented deportations of busloads of Venezuelans to CCOT out of Texas. That stay was an unsigned per curiam opinion, sending the case back to the Fifth Circuit to determine what constitutes meaningful notice and a right to contest this deportation. And they asked the Fifth Circuit to determine whether courts can look under the hood of this Alien Enemies Act proclamation and say, no, we're not, when Trump announces that we're under invasion by Venezuela. And in that case, Kavanaugh filed a concurrence, and he said the circumstances call for a prompt and final resolution, which likely can only be provided by this court. At this juncture, I would prefer not to remand to the lower courts and further put off this court's final resolution of the critical legal issues. So Kavanaugh basically said, I don't understand why we're waiting around for the district court and the Fifth Circuit to weigh in here. Like, who cares what they have to say? It's going to be up to us, the 6 conservative justices, to decide what the law is. Like, let's grant cert now, order briefing, and decide.
Yeah.
All right, we're going to take another ad break unless you're a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case you will not get an ad now. You will not get an ad ever. And we're back. Okay, before we get into talking about the actual holding, I think I want to kind of take a 90,000-foot view here. What we're talking about in the Chevron case was the Supreme Court saying to the executive branch, we're going to decide what the law is, not you, right? Deferring to the executive branch's interpretation of statutes, that's done now. We're not going to do that. We're going to tell you what the law is. And in this term, what they've done in this case where they blew up injunctions in the birthright citizenship case is say to the lower courts, we're not going to let you guys decide either, because we 6 have the power now to make policy, to make law for this entire country. And so we'll let you guys issue, you guys being the trial judges, we'll let you issue, injunctions that affect your little patch in your district, the Western District of Texas or whatever. But you can't make law for the country because that's what we do. And so Justice Barrett kind of wraps this decision in like a kind of a veil of judicial modesty. Like, we don't want these trial judges exceeding their authority, and there was no nationwide injunctions in ye olde England. But what she's really saying is only we 6 conservative justices have the power now. That's not judicial modesty at all.
No. And I have to say, this is an Andrew was wrong, right? I said on the show that we recorded Thursday that aired Friday before this decision came out that I thought the Supreme Court was going to curtail nationwide injunctions, right? I thought they'd narrow the scope or come up with some made up rule that requires litigants to post a bond, or I don't know. I thought it was going to be bad. But I didn't think the Supreme Court was going to say that judges have no power to issue injunctions because, presumably there will be a Democratic president again who tries to do things like, forgive student loan debt or protect consumers or protect workplace safety or, all of the things that right-wing courts issued nationwide injunctions against when Biden was president. And I really thought the court would want to leave that in place. But I underestimated both how deeply committed that the Roberts Court is to the stupid one right answer Platonic view of jurisprudence, and I underestimated how clever they are.
Yeah, I'm gonna disagree with you here because I think it's a category error. I think that we approached it. We said, well, they'll pare back nationwide injunctions because we thought about this in terms of nationwide injunctions being a tool to rein in the Trump administration specifically. But I think that's thinking too small, right? The reason that you get rid of nationwide injunctions, if you're this Supreme Court, is because the lower courts no longer matter. You have the power. You will have the power perhaps for an entire generation to come. And so it's not about the Trump administration. It's about the conservative project, which the Supreme Court is going to enact. And in that project, the lower court judges who are trying to interpret the law as it is on the books, even the Fifth Circuit in the Texas porn case, which did in fact adhere to the law. The lower court saying, well, this is what stare decisis would have us do. Irrelevant. Because stare decisis is no longer relevant. The only thing that's relevant is that these 6 judges, these 6, Supreme Court justices are going to implement their conservative agenda. So it wasn't about the Trump administration at all, really. It was about their own power.
I think that is exactly right. And when you say the conservative agenda, you mean the radical Project 2025 agenda to reshape American society. And you are correct. This Supreme Court is completely on board. With respect to the birthright citizenship executive order, the way that this interacts with what the Trump administration is doing is now everything, right, that the Trump administration does is going to get funneled to the lower courts as a class action. We wrote about this in depth in our blog post, and we talked about the mechanics and how the Supreme Court has been reining in Rule 23 class certification, and they're going to continue to do that, right? Alito wrote a concurrence that said, don't take this as an invitation to expand class certification, lower courts. We're watching you.
Right. I think I just saw somebody on BlueSky talking about Amy Coney Barrett playing in our faces when she says, oh, there's definitely a remedy because you could just do it as a class action, right? That it's so grossly disingenuous to say that when the Supreme Court and conservative courts in general have been making it much harder to get class certification.
Yeah. So let's talk about how challenging this particular wildly unconstitutional executive order is going to play out in practice. So, Executive Order 14160 says you are not a citizen if you were born here unless your parents were citizens or lawful permanent residents. That is not the law, has not been the law for 125 years. There's clear Supreme Court precedent. There's clear language in the 14th Amendment. Trump administration doesn't care. And Section 2A of that executive order directs every single government agency to begin developing and issuing what it calls guidance as to how that agency can comply with this illegal citizenship interpretation. Specifically, it says that no part of the federal government can issue documents inconsistent with that interpretation. That means Social Security numbers. So the Social Security Administration will stop issuing Social Security numbers to people that it deems fall outside that definition. And Section 2A also says that the federal government can't rely on state legal documents that are inconsistent with that interpretation. So that means you are going to see directives about not accepting blue state birth certificates and driver's licenses for purposes of issuing passports or providing federal benefits. It's going to be a disaster.
Yeah, we've seen the Trump administration try this the first time around when they said if New York State didn't allow them to go trawling through the driver's license database to find undocumented immigrants, that you weren't going to be able to use your driver's license from the state of New York to get on an airplane. Mm-hmm. So here's how the rubber's going to meet the road here, which is that the states are going to bring the same actions that they've brought before. And they may not bring them as class actions. They may bring them as class actions on the part of their citizens. The Supreme Court opinion wasn't real clear on whether the state plaintiffs had standing to get injunctions. They said nationwide injunctions are no good, and so all of those injunctions are dissolved. They were not super clear on whether the states themselves, because states have an independent interest apart from the rights of the people who are born there, citizens who are born there. They have an interest in the orderly administration of their stuff. They have to decide whether they're going to issue birth certificates, right? And Texas would like to issue a two-tiered, a birth certificate for citizens and then a sort of a crappy second-tier birth certificate for what they deem to be non-citizens. So states do have a cognizable interest. And the Supreme Court knows that district court judges in blue states are going to issue a district-wide injunction and force the federal government to issue Social Security numbers to children of undocumented immigrants born in Massachusetts and Maryland, right? Everybody knows that's what's going to happen.
Right.
But the problem is that in red states like Texas, they're going to start issuing those, second-class citizen driver's license and birth certificates and whatever to comply with the executive order. And the Attorney General of Texas, the aforementioned Ken Paxton, is not going to sue. He's delighted to, attack immigrants any way he can. And so it's going to fall on individual plaintiffs in Texas, or I guess the plaintiffs would be the babies, but it will be their parents who will have to sue to vindicate their children's rights to get a Social Security number. And there will be a lot of hurdles, right? They'll be filing in district courts that have a lot of very conservative Trump appointees in them, even if they avoid single judge districts like Amarillo, where they park Judge Matthew Kaczmarek. The only nice part of this is that since you can't issue nationwide injunctions, Judge Matthew Kaczmarek just became a whole lot less relevant. He's the one that purported to block mifepristone nationwide. Anyway.
Maybe the Fifth Circuit will reverse itself on getting rid of single-member districts now.
Right,
who knows?
exactly, right. But even if you get a good district court judge, the class certification decision is immediately appealable. So you get a good judge in some district court in Texas, you get Judge Briones or something, that's going to be appealable to the Fifth Circuit. And if either the district court or the Fifth Circuit rule that the class is invalid, that is binding on all purported class members. It can't be challenged in any other court. You can appeal to the Supreme Court, but they can just deny cert without any explanation.
Yeah. So the net effect of all of this is going to be, with respect to citizenship, this crazy, unworkable patchwork across the country. And it's going to be very, very hard for the people who need it most to get the judicial relief that they need, thanks to this opinion.
Yeah, I just want to say before we leave this segment, I don't think that the Supreme Court is going to invalidate birthright citizenship. I don't. Yeah. I don't think that the votes are there to do it. I mean, I think that there are going to be some votes for it, which is disgraceful and insane. But I don't think that the Supreme Court is going to invalidate birthright citizenship. But I think what they wanted to do here was kind of give the Trump administration the win on their way to asserting that they are the only law in this land.
Yeah,
right?
I think that's exactly right.
It does that the birthright citizenship, the chaos that they're unleashing, is not the primary goal here. The primary goal was to say, we are the law now.
Yeah. And I don't think they have to rule against birthright citizenship for the Trump administration to effectively get what it wants.
Okay. We will be right back for Sam Alito's Children's Storybook Hour after this brief ad break. And we're back. Okay, you guys remember the praying football coach case, the one Andrew literally cannot stop himself yelling about every time it comes up? That's the one where Justice Sotomayor, in her dissent, included a photo of the high school football coach praying on the 50-yard line with the team at halftime to refute the majority's lie about the school trampling this poor man's right to private prayer with the teammates. That case is Kennedy v. Bremerton School District.
I am being very, very quiet.
Uh-huh. All right. Well, I regret to inform you guys, the Supreme Court's conservatives have outdone themselves in an orgy of mendacity involving yet another religion in schools case.
I will not yell. I will not yell.
Yes, you will.
I will not yell.
Not taking that bet. We are talking, of course, about Mahmoud v. Taylor, which involved a challenge to Montgomery County, Maryland's inclusion of books about LGBTQ plus characters as part of its curriculum.
Or, as Project 2025 calls it, porn.
Yeah, that's not even a joke. Project 2025 explicitly said that there was no First Amendment protection for pornography.
Which is completely wrong on every level, even after Justice Thomas's insane opinion in Free Speech Coalition v. Paxton that we talked about in the first segment.
And Project 2025 defines porn as anything with LGBTQ plus characters. We have seen schools across the country yanking books off the shelves because parents make this same argument, and it's bigoted and it's gross. Acknowledging that gay and trans people exist and should not be shunned as perverts is the farthest thing from porn. Actually, let me take that back. The farthest thing from porn is this book called Uncle Bobby's Wedding, which made Justice Sam Alito so mad that he had to lie his face off. This book is about a little girl named Chloe who is sad because her favorite uncle is getting married to his boyfriend. And it's very clear that she is sad because she's worried that he won't have time for her anymore. I'm going to read you the actual text. "But," said Chloe. "But what?" asked Uncle Bobby. "But I still don't think you should get married. I want us to keep having fun together like always." "I promise we'll still have fun together," said Bobby. "You'll always be my sweet pea." Okay, so then everybody,
Porn.
They get married and is happy, and I'm going to tear up, but I'm not going to tear up right now. Anyway, so Sam Alito says the book is coy about the reasons Chloe doesn't want her uncle to get married. The implication being that she may harbor secret homophobic feelings, which I know is crazy, but I know that's what he thinks because that's what he said during oral argument.
Chloe is 6, and she's deeply opposed to gay marriage. Yeah, you bet, Sam. Mm-hmm. Here's what he says. Actual reading from an actual opinion written by an actual Supreme Court justice. "The book is coy about the precise reason for Chloe's question, but the question is used to tee up a direct message to young readers. Bobby and Jamie love each other," said Mummy. "When grown-up people love each other that much, sometimes they get married." Ibid. "The book therefore presents a specific, if subtle, message about marriage. It asserts that two people can get married regardless of whether they are of the same or opposite sex, so long as they love each other, which just so happens to be the law of the land, Sam."
Yeah, it's not an opinion. It's a fact.
Right. That view is now accepted by a great many Americans, but it is directly contrary to the religious principles that the parents in this case wish to instill in their children.
So that gets to the issue. Religious parents want an opt-out because teachers might read Uncle Bobby's Wedding to their kids and it would convey that gay marriage is okay. And that interferes with the free exercise of these parents' religion. That's the holding of this case.
There's some shouting coming on, Liz.
Well, I did warn our listeners.
Oh, okay. Look, Alito lied about the book.
And just like in the Bremerton case, Justice Sotomayor made sure that everybody knew it was a lie. She included in an appendix with every single page from that Uncle Bobby's Wedding book in it.
God bless Justice Sotomayor. But look, if you have to lie about a children's book to make your case, kind of gives the game away. But all right, let's unpack what purports to be the legal reasoning here, because the 6 conservative justices based their ruling on a 1972 Supreme Court decision called Wisconsin v. Yoder. And they also just flat out lied about that case, right? So the Yoders were Amish parents who did not want to send their kids to school after the 8th grade. So, right, the law in Wisconsin at the time was that you could drop out of school at 16, and they wanted their kids to drop out of school at 14. This was the height of the Warren Court, the most progressive Supreme Court in our nation's history, right? And so the majority opinion, I think somewhat understandably, even though I disagree with it, was like, look, the Amish are this super duper minority of misunderstood weirdos, right? Like we're over a decade from Witness coming out, right? Like no one knows who these people are. So look, let's let them preserve their little enclave in eastern Pennsylvania. Let's let them pull their kids out of school.
I mean,
early.
Wisconsin, but yeah.
Yeah, well, Wisconsin and eastern Pennsylvania, and I don't know.
I know, it's where I see them too.
Right. If we make them send their kids to school, their kids aren't going to be Amish anymore. And let's not, get rid of the Amish. Let's give them a religious accommodation for their sincerely held religious beliefs. And to be fair, I'm steel botting this argument here, right? Like, I think this decision was wrong because I side with the dissent from that case. That Amish kids deserve the right to decide whether or not to leave the community. This is a society, like we owe it to them to give them at least the minimal education they need rather than, let the parents say, no, you're going to continue to live on the farm.
Right. So here's the slippage. The majority claims that mere exposure to ideas that don't accord with a parent's religious belief violates the free exercise clause. And they cite Yoder in support of this, but that was not the holding of Yoder at all.
No.
You know what? Let's let Justice Sotomayor explain it. She says the problem in Yoder was not that the law exposed children to material that would incidentally undermine their religious beliefs, but that it compelled Amish parents to do what their religion forbade, send their children away rather than integrate them into the Amish community at home. Yoder is distinguishable because the challenge law affirmatively compelled the parents to perform acts undeniably at odds with the fundamental tenets of their religious beliefs. That is not true here. It also bears emphasis that the parents in this case remain free to teach their religious beliefs and practices to their children at home, as petitioners acknowledge. The parents in Yoder, by contrast, were prohibited by the challenge law from engaging in religious teaching at home that was critical to integrating Amish children into the Amish religious community because the law required them to send their children away to school during that same time. It was thus impossible to both comply with the law and engage in the religious teaching at home deemed necessary by the Amish parents.
Right, because school occurs during the day when the farming occurs. You can't just say, we'll do the farming in the middle of the night, right? And that obvious set of distinctions is why Alito had to contort himself into a pretzel to say that Yoder was really about forcing Amish kids into exposure to worldly ideas. But it wasn't. It was about making the kids engage in conduct, right? Going to school rather than churning butter or shoeing horses or whatever, right? Like, it's not like the parents had a subject matter based objection, right? Like, they're like, oh yeah, pre-algebra is fine, but like algebra 1 is right up. No, it was the act of going to school at all during the day. It was not the content of the coursework that Ma and Pa Yoder were objecting to.
Right. And frankly, the fact that the liberals joined in Yoder is to our everlasting shame, as is our tolerance of the disgraceful undereducation of Orthodox Jews in New York, which is something I could yell about at length, but I will do that some other day.
I am here for that.
There will be so much Yiddish, so that those poor boys who receive no instruction in English will understand it. Anyway, Yoder is not the only precedent these guys are tossing aside here.
No, because Yoder was quickly recognized as an outlier. The Supreme Court was like, okay, yeah, we were trying to help the Amish out. We recognize that our bad, right? Because look, if the Amish could get out of school, then maybe the Jehovah's Witnesses could get out of paying taxes. No. Right. And so in 1988, the Supreme Court decided a case called Ling versus Northwest Indian Cemetery Protective Association that held that forcing a father to get a Social Security number before his daughter could get access to government benefits did not interfere with his free exercise of religion, even though the father sincerely believed that Social Security numbers were the mark of the beast, right? So the court's curtailing these kinds of exceptions, and that came to a head in 1990 when noted liberal squish Antonin Scalia authored Employment Division versus Smith, which said that Native Americans were not entitled to a religious exemption to use peyote because it violated the local laws. And the principle that he outlined is that you have to follow what he called neutral laws of general applicability, even if they interfere with how you'd like to practice your religion. In that case, maybe the only thing Antonin Scalia ever got right in his entire miserable life, right?
Yeah.
Like, that case, Employment Division v. Smith, is still good law. I mean, supposedly.
Right.
The point here is that there is no precedent, there is no history, there is no tradition that says reading a book that makes parents sad in their religious fee-fees violates the free exercise. There can't be. This is a society.
Right. Yeah, this holding is just pure bigotry. Yeah, Alito says, these books carry with them a very real threat of undermining the religious beliefs that parents wish to instill their children, cites to Yoder. Like the compulsory high school education considered in Yoder, these books impose upon children a set of values and beliefs that are hostile to their parents' religious beliefs. Again, citing Yoder. And the books exert upon children a psychological pressure to conform to their specific viewpoints. The books, therefore, present the same kind of objective danger to the free exercise of religion that we identified in Yoder. That objective danger is only exacerbated by the fact that the books will be presented to young children by authority figures in elementary school classrooms. Let's note that the psychological pressure to conform here is pressure to acknowledge the reality that gay people are indeed entitled to get married. I mean, Cabin for a Second, the book about a trans kid being grateful to his mom for accepting his gender identity. That's another book that Alito objected to. It is settled law that gay people can get married in all 50 states. It is an objectively true fact that, as Chloe's mom said, when grown-up people love each other that much, sometimes they get married, even Adam and Steve. So the court's 6 conservatives are saying here that parents' religiously based bigotry, their insistence that gay people should be stigmatized, is a First Amendment issue.
Right. And you want to talk about trans kids? The court just ruled in Skermeti that parents of trans kids do not have a right to determine their children's medical care, right? The state can forcibly cut off gender-affirming care for trans children. I mean, there really is no better illustration that this court starts with the result it wants and works backward, and it is motivated by religious animus alone.
Yeah, so I guess the silver lining here is that the Supreme Court seems to be saying that schools can survive this challenge. They can still read these books if they allow parents to opt their children out, which is ridiculous and unworkable. That's why the Montgomery County Public Schools abandoned that policy, 2 years ago. Mm-hmm. And it's inherently stigmatizing. Like, if you need a permission slip to talk about gay kids, then those kids are inherently stigmatized. And like Justice Sotomayor said, allowing parents to treat a gay teacher's family photo as X-rated or even R-rated, it's like a separate water fountain. It is separate but equal. It is inherently stigmatizing. And speaking of which, how soon until we see parents who oppose interracial marriage suing to be able to opt their children out of reading books about black and white couples?
Your flat earth parents suing to opt out of the globe.
Yeah, for sure. Like, please let some smart lawyer come up with a lawsuit to opt kids out of, like, hagiographic bullshit about the Confederacy.
I'm pretty sure it is a tenet of the Satanic Temple that it's against their religion to teach kids that the Civil War was about states' rights. So go for it, guys.
Displaying the 10 Commandments violates my freedom of religion.
It does.
That's coming. That's coming, right? That's that Roke v. Brumley case, which we are going to talk about as a Fifth Circuit case. We will get to it. But I do kind of want to say something serious, even as we're making these jokes, because every kid in America spends November and December practicing Silent Night and like playing Secret Santa and doing all kinds of explicitly Christian things. And anyone who pushes back on that is accused of perpetrating a war on Christmas. I mean, Trump ran on saying, we could say Merry Christmas again. That is what they were saying. Christians are the majority, and we get to decide. And this decision in Mahmoud v. Taylor is a vote in favor of religious indoctrination, because they don't mean that any religious objection must be honored.
No.
They mean objections that align with their specific conservative worldview. Like, try being a Hindu and suing based on your belief that depictions of meat offend your sincerely held religious beliefs. And so the school has to, like, opt out. Right? Offer you an opt-out of any book about hamburgers, right? You're not going to get it because it would be ridiculous. And this is equally ridiculous. This is just bigotry, plain and simple. The Supreme Court does not care about precedent, and they don't care about consistency. They have the power now, and they're going to use it.
Yeah.
All right, that is going to do it for us today, you guys. Thanks for hanging out. If you enjoyed the show, please leave us a 5-star review on your podcast platform of choice. And if you want to support the show, you know what to do. We will be back on Thursday with written content and on Friday with another show. Try and stay cool if you are in the hot hemisphere. See you guys.
Law and Chaos Podcast is a production of Ray Zipson Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Ray Zipson Media, LLC, all rights reserved.